The United States Supreme Court just ruled to uphold the Protecting Americans from Foreign Adversary-Controlled Applications Act. This law was actually created by Congress and signed into law by President Joe Biden back on April 24, 2024. Essentially, this legislation mandates that ByteDance, the Chinese parent company of TikTok, sell off, dispose of, or relinquish ownership of its U.S. operations or face a nationwide ban of the app. The concerns before the Supreme Court ruling was, is this constitutional? Can Congress even do this? Now, with the backing of the Supreme Court, this law is found to be constitutional and therefore a legitimate one to shut down the app. But the concerns arise around the idea of free speech in America. And here at Civics Review, we're going to look into what the Constitution says about the following questions many people have right now. And I realize as the posting of this video that Donald Trump has just created an executive order to extend the period of time before the law's prohibitions take effect. But this executive order does not undo the law Congress created, nor the ruling of the Supreme Court, and so this is still a legitimate concern for Americans' right to free speech. So again, the concerns are, what power grants Congress the right to do this? How does the Supreme Court come to a decision like this? And what are the limitations to American rights to free speech? As I'm sure you can imagine, the recent story on TikTok and the First Amendment rights of free speech has generated a lot of controversy in the media, contributing to an already polarizing landscape. That's why understanding the bias and the background info on your news source is helpful to make sure you're getting the whole picture on the news. This is why I asked Ground News to partner on this video in particular. Ground News aggregates related articles from around the world into one accessible platform, and for every article, Ground News provides additional context, such as the potential bias of the source, their factuality, and even the ownership of the outlets themselves. Let's take a closer look at the way Ground News presents the TikTok story. You can see here it's compiled 947 sources from around the world, giving me a quick summary of the left, center, and right's views. The left highlights economic dependence on TikTok, presenting Trump's executive order as relief for business, while the right portrays Trump as a savior amidst chaos, emphasizing political struggles surrounding national security and tech dependence. These differences in reporting affect the way we interpret a story and can change our worldview without us even noticing. Go to ground.news/CR or scan the QR code on screen right now. They're offering my subscribers 40% off the Vantage subscription, which gives you unlimited access to all the features we covered. By subscribing, you're not only supporting an independent news platform that's working to make media more transparent, you're also supporting my work. Okay, now that we've sorted out factuality and bias in our sources, we're ready to investigate. So, where does Congress get the power to do this? Congress's authority to make laws banning TikTok or other similar platforms can be derived from specific powers granted by the U.S. Constitution. As you are well aware, the Constitution is made up of 7 sections, with Article 1 being the largest part of the document. It focuses on the legislative branch and the lawmaking process. Inside Article 1, Section 8, Clause 3 to be exact, we find the Commerce Clause. This gives Congress the power to regulate commerce. It reads, Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Oh, you're waiting for more. No, that's it. That's all the document says in this clause. And with these few but mighty words, Congress has the enumerated power to regulate or restrict TikTok's operation under the authority to manage foreign commerce. This clause has been historically used to regulate activities affecting trade, communication, and data across national and state boundaries. Since TikTok operates as an international platform owned by a foreign company, which is ByteDance based in China, Congress sees itself as absolutely being able to create laws regulating it. Look, with so few words in this section, there is a lot to interpret. What exactly does regulate entail? Forcing a shutdown? Demanding a company sell their ownership to a U.S. company? And what is defined as commerce? TikTok operates as a free-to-use application, but these terms in the Constitution have all been historically interpreted over many Supreme Court cases in the past to give us a pretty good idea of the reach and limitation of our bicameral legislation in this area. But even if the simplistic terms found in this section weren't enough, Congress wields its mightiest power in Article 1, Section 8, Clause 18, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. This is known as the Necessary and Proper Clause, or the Elastic Clause, as it allows Congress to really do whatever the heck it wants, as long as it deems it necessary or proper to do so. This greatly allows Congress to expand their power when needed to create laws and control things. But is it too much power? This was a major point of contention at the Constitutional Convention, where the document was debated and written up. The group that wrote the Constitution, including the Elastic Clause, was the Federalists. They supported it as a critical component of the Constitution, arguing that it was essential for the federal government to function effectively. They saw it as a practical and flexible tool that allowed Congress to fulfill its enumerated powers, ensuring that the government could adapt to unforeseen challenges and carry out its responsibilities. Hamilton argued that the Constitution could not possibly list every specific power or action Congress might need to undertake. In the Federalist number 33, he writes, "It may be affirmed with perfect confidence that the constitutional operation of the intended government would be precisely the same if the necessary and proper clause were entirely obliterated, as if it were repeated in every article. They are only declaratory of a truth which would have resulted by necessary and unavoidable implication from the very act of constituting a federal government and vesting it with certain specified powers." Hamilton is essentially arguing that the clause does not grant Congress additional powers, but merely clarifies the authority already inherent in the Constitution. It is a practical and logical extension of the federal government's ability to fulfill its enumerated responsibilities. But this is about the time where we cue in the Anti-Federalists, the other group at the Constitutional Convention that was not happy with how much power was vested in the national government. They were concerned over states maintaining their rights and powers, as well as the rights of the individual. They refused to sign the document without promise of a Bill of Rights. Their key concerns of this clause were its vague and broad language. They feared this vagueness would lead to an unchecked expansion of federal authority. They were also worried about its potential for tyranny. The Anti-Federalists were deeply skeptical of a centralized power. They believed the Elastic Clause could be used by Congress to justify virtually any action, undermining the balance of power and paving the way for tyranny. Another point they made was the erosion of state sovereignty. Now, they worried that the clause would diminish the power and autonomy of the states by allowing the federal government to interfere in areas traditionally managed by state governments. They saw the clause as contrary to the principles of federalism, the concept of sharing powers between states and the national government. And their final conflict of this clause was that of enumerated powers themselves. What's the point of writing down limitations to powers and rule sets if you're going to include this clause that allows Congress to simply override every word of the Constitution? Well, we know in hindsight who won the argument. The Federalists were able to persuade the Anti-Federalists that checks and balances would be able to curtail Congress. And seeing as how weak and ineffectual Congress was in their time under the Articles of Confederation, maybe it was hard to imagine Congress becoming the monster that it is today. So yes, Congress absolutely has the power to create this law. And they did. We all should know the Schoolhouse Rock song about how Congress writes laws, but this demonstrates that our elected legislators were in a majority agreement that this law was needed to protect America, as was the president who signed it. And now we pass the baton to the Supreme Court. How does the Supreme Court come to a decision like this? Is our free speech being infringed upon or not? Let's now examine Article 3, which defines the role and power of the Supreme Court. Unfortunately, it's 377 words long and incredibly vague. This section of the Constitution does not mention any powers of the Supreme Court to review the actions of Congress or the President in order to determine their constitutionality. This power, which is known as judicial review, was actually established by judicial precedent in the landmark Supreme Court case of Marbury versus Madison way back in 1803. Since then, the court has been able to rule on the actions of the other branches to determine if what they do is constitutional or not. The opinion of the court regarding the Protecting Americans from Foreign Adversary-Controlled Applications Act was what we call an unsigned opinion with no dissents. This is typically considered a unanimous decision. These rulings are often referred to as per curiam opinions, meaning by the court in unanimous agreement. In such cases, the court issues a collective judgment without attributing it to a specific justice, and no individual justice publicly disagrees with the outcome. However, it is possible for justices to concur or dissent privately without noting it publicly, meaning they might not agree fully with the reasoning but do not formally object to the decision. As a result, while an unsigned opinion with no noted dissents is treated as unanimous, it does not necessarily reflect complete agreement among the justices. That being said, not one justice formally objected to the decision that Congress is within their ability to ban TikTok, and that it is not an infringement of free speech rights in America. The right to free speech is found in the First Amendment, which stands side by side with Americans' rights to petition their government, to not have the government establish a religion or deny the right to practice any religion freely, to peaceably assemble, and freedom of the press. But of course, these rights aren't truly unlimited. The Supreme Court has ruled to limit or deny many of these rights, usually based on the balancing test, which weighs the individual's constitutional rights against the government's interests or the interests of the public good. And these are a few ways in which they can limit our free speech. And the first is incitement to imminent lawless action. So if your speech is going to do just this, it's most likely not going to be protected by the First Amendment. Another one is true threats, which communicates a serious expression of intent to commit an act of unlawful violence against an individual or group and is also not protected. The same goes for obscene speech, pretty self-explanatory. Defamation or false statements that harm another person's reputation can and will be restricted if they meet the legal standards for libel or slander. Fighting words, which is speech that, by its very utterance, inflicts injury or tends to incite an immediate breach of peace, is also not protected. And the last and most relevant one is government interests. Now, the government may impose restrictions in cases where it has a compelling interest, such as national security or regulations in public spaces. So what's the balance in the TikTok case? We have the rights of the people to use and participate on TikTok, and on the other hand, we have government interests. In this case, the national security concerns regarding data collection practices and potential ties to the Chinese government. Does the individual's rights to this app supersede the potential danger of a foreign adversary having this information and potential influence over its users? Well, when TikTok brought its case to the Supreme Court citing infringements on its users' free speech, Justice Ketanji Brown Jackson suggested TikTok was wrong, that the case violates its First Amendment rights, and said she thought the case was more about TikTok wanting to associate with ByteDance than its speech being silenced. Chief Justice John Roberts said the federal law was not a burden on TikTok and its users' expressions at all, arguing Congress was fine with user speech on the app, but just not a foreign adversary gathering information about the app's users. Justice Brett Kavanaugh brought up past examples of the U.S. blocking broadcasting companies from having ties to foreign governments, and brought up the government's concerns about TikTok collecting data on U.S. users, which he said seems like a huge concern for the future of our country. And in the eyes of this court, you can see the balance tip in favor of protecting the U.S. against foreign adversaries. Several justices also mentioned alternatives to the app that were not deemed a critical threat to the government. Justice Samuel Alito asked TikTok creator's attorney about whether his clients would actually be harmed if TikTok went away, or if they could just go to a different platform, questioning whether their attachment to TikTok was akin to somebody's attachment to an old article of clothing that could be replaced, or if ByteDance had truly created a magical algorithm that no other tech company could possibly replicate. And that's how we ended up where we are. The rights of Americans are potentially always hanging in the balance. In the case of TikTok users, the right to use the app is now banned on the grounds that the information being shared with a foreign adversary is deemed too dangerous. They are, however, free to use other similar websites and apps that are not connected with the Chinese government. Could this ruling be overturned? Yes. and the only ones with the ability to overturn the Supreme Court's rule would be the Supreme Court's ruling. We've somewhat recently seen this in the overturning of Roe v. Wade. As much as news sources want to tell you that Donald Trump is the reason that Roe v. Wade was overturned, this is simply not the case. No president has the power, as backed by the U.S. Constitution, to do this, and Congress as well does not have this power. Only the Supreme Court can overrule itself. But as it is right now, you might want to think about finding a new app to watch cat videos on. Okay, that's it for now. Thanks so much for sticking to the end of my video. I hope you enjoyed it. I hope you learned something. We'll make more videos soon.